Hello and welcome to Talk Clayton's podcast number 5. I'm Reid-Ellaby and I'm joined by David Evans. In today's podcast, we are looking into the complex world of financial regulation to consider the Senior Manager and Certification Regime, or SMCR for short, which came into force on the 7th of March of this year. Now, the topic has been doing the rounds in the financial press for the last year, and it's grabbed its fair share of controversial headlines, and some might say a healthy dose of scaremongering. So, David, what will we actually be considering?
Well, we're going to be looking at some of the HR and employment law considerations arising under the new regime, which is all about increasing personal accountability for wrongdoing in the financial sector. Firms and individuals affected by the changes need to understand their obligations, or they will be costly and, for individuals at least, potentially career-limiting consequences.
So, what is the new regime and what does it actually replace?
SMCR is a new regulatory framework replacing the old approved person regime. It was introduced by the Financial Services Banking Reform Act 2013 and will apply to UK banks, building societies, credit unions and PRA-designated investment firms. It will also apply to UK branches of overseas banks.
And hedge funds, investment firms, are they covered too?
Not yet, but it will be extended to all financial services and FSMA authorised firms from 2018, so it will include interdealer brokers and hedge funds. So what does the new regime look like and who's going to be affected, Rachel?
Well, under the old regime, in order to perform certain controlled functions, the individual needed approval from the city watchdogs, so that's the PRA or the FCA. Once granted, they became an approved person, and this meant that they were accountable to the regulator and they had to abide by a set of conduct rules.
So what's changed?
Well, now, instead of having approved persons, we have a regime with 3 tiers. So, senior managers, certification staff, and finally a new set of conduct rules. And you can see these all listed on the slide. So, if we take each of these in turn, you can see that at the top we've got the senior managers, and these will be the individuals performing what are called senior management functions. And these people will need pre-approval by the regulator.
So who are we talking about here?
Well, we're talking about the people at or near the very top, so board level, executive committee. But this smaller cohort bear more responsibility. They're subject to a statutory duty to take reasonable steps to prevent regulatory breaches in their areas of responsibility. So at the next rung, beneath senior managers, we've got another layer of staff, and that is certification employees. Now, these individuals will not require regulatory approval, but they will need to be certified by the firm itself as being fit and proper to perform their roles.
So who will they be?
Well, in essence, it's going to be anyone who could pose a risk of significant harm to a firm, and it's for the firms themselves to certify employees, and this has to take place annually. We can probably expect firms to build the annual certification process into their existing performance management process.
When will they have to do this by?
Firms have until the 7th of March 2017 to issue these certificates. Moving on then to the third tier, and that is conduct rules. And you can see these listed out on the slide. Now, these are broadly similar to the old regime. Rules 1 to 5 apply to senior managers and certification staff, whereas SM 1 to 4 only apply to senior managers. But from March 2017, the first tier, so 1 to 5, will apply to virtually all staff.
So what happens, Rachel, if you breach the rules?
Well, if you breach the rules, the regulator can take enforcement action against you as an individual. So you could be fined, suspended, or even given a lifetime ban.
Will it end there?
No, enforcement action will also be taken into account when assessing your fitness and propriety. So a senior manager could lose their approval, while a certified person might not have their certification renewed. Enforcement action is also going to show up on your reference for the next 6 years. So it could prevent or put at an obvious risk an external or even an internal move.
So what steps do firms need to take if they uncover a breach of the rules?
Well, they need to act quickly. If there's a known or suspected breach of the rules by a senior manager, firms have to report this to the regulator within 7 business days of becoming aware of it. Now, they'll have to complete a Form C if the individual's approval is completely withdrawn, or a Form B if the individual remains in post. Now, breaches by certification staff, on the other hand, only need to be reported to the regulator on an annual basis.
So what should firms be doing in relation to the new conduct rules?
Well, what's crucial is that firms ensure they have suitable monitoring and reporting procedures in place to identify any breach of the rules. They're also going to have to provide training to employees subject to the rules so that they're fully aware of the scope of their obligations. This is going to be especially important when the rules are rolled out to the rest of employees next year. So, David, in practical terms, what's actually going to be changing with the new regime?
Well, for one thing, the paperwork. Any senior manager application must be accompanied by 2 documents: a Statement of Responsibilities, SOR, and a Management Responsibilities Map. The Management Responsibilities Map sets out the reporting structure in the firm and within particular teams. The more onerous document is going to be the SOR, as this is personal to the senior manager.
So, what is an SOR?
Well, this is the document setting out in detail the specific responsibilities of that manager. It's not going to be a tick box exercise. There's space on the form for 300 words next to each responsibility. So it's intended to be a live document and will need to be updated when the individual's role changes or they take on or lose any part of their responsibilities.
So I assume then it's going to be a significant document for senior managers.
Yes, it's going to be used to hold a senior manager to account for any failings or breaches that take place under their watch, so it is going to be a highly significant document. I suspect that the SOR will be the subject of detailed negotiation between senior managers and their employers, and both may encourage the employees to take legal advice on the document before signing, in order that they can thrash out any ambiguities in advance.
So what sorts of things should I be considering if I'm applying to be a senior manager?
Well, from an individual's perspective, you're going to want to ensure that the document accurately reflects what you're actually going to be doing and that there's no ambiguity, because if there is, you're going to be on the hook if something goes wrong. We're likely to see individuals try and minimise their responsibilities, dubbed in the financial press as juniorising, and also to expect senior managers asking for more money.
So, David, what sorts of considerations will there be for the firm itself?
Well, the firm will also want to ensure that all the gaps are plugged. We can expect to see SORs appended to employment contracts and so becoming part of the individual's terms and conditions of employment. If the individual fails to abide by the statement, they'll be in breach of contract and also face disciplinary action.
But I'd assume that when a senior manager starts in a role, they'll effectively have a clean slate.
No, and that's an important point, Rachel. If you take on a senior manager role, you can be responsible for things that happened before you came into post. You're effectively being parachuted in, so if there are any historic and ongoing issues, you'll want to know straight away. So what steps can firms take to help senior managers ensure a smooth transition when they take on a new role?
Well, outgoing senior managers should be made to prepare a comprehensive handover certificate, showing how that senior manager has exercised their responsibilities and also identifying any issues of which their successor ought to be aware. We expect, as a matter of good practice, to see affected firms introduce a policy of completing handover certificates on change of role or departure, even though at present it's not a legal requirement.
So what sticking points could there be, Rachel?
Well, the most obvious one is probably going to be if the outgoing senior manager leaves the firm on acrimonious terms. Now, there's going to be serious personal regulatory risks for the incoming senior manager if a proper handover isn't carried out. So if individuals leaving enter into a settlement agreement with the firm, which is often the case for senior individuals, it's likely that firms are going to want to demand as a condition precedent to any settlement payment that a fully comprehensive handover certificate is prepared by that individual.
Is there anything else incoming senior managers can do to protect themselves?
Well, they should firstly find out if they're covered by the firm's D&O insurance policy, and they can also request indemnity protection in the event they're held liable for things that happened before they joined, or if they're not given a proper handover.
What else might they consider?
They might also seek an indemnity in their employment contract in respect of any legal costs they incur when defending themselves during any investigation by the regulator. We do know that various indemnity and insurance products are on offer to deal with this new challenge. So, David, what about regulatory references? I thought that the rules were going to be changing here.
Well, we're still awaiting the final rules on the changes to regulatory references, but we are expecting those to be published sometime over the summer. We do know that more detailed references will be required, and it will no longer be possible to give a simple reference with just the individual's job title and dates of employment. They're going to have to take a prescribed form.
So, what sort of impact might this have, looking at it from the firm's perspective?
Well, the most likely impact is going to be in the context of negotiated exits. Settlement agreements should not be drafted in a way that purports to restrict the reference that the firm gives. Any reference is going to be subject to regulatory obligations. Firms should be checking their settlement agreements to ensure no limitations on their ability to disclose relevant information has been put in there in relation to regulatory references.
So, when firms come to vet senior managers or certification staff, how far back are they now having to go?
Well, in short, 6 years. What's crucial here is the obligation on firms to update regulatory references of both existing and former employees in light of new facts, for example, any evidence of misconduct or any managerial failing arising some years down the line, even if the individual has left the firm. So firms need to have processes in place to record and monitor known and suspected breaches of the rules by existing and former employees. And if you're an individual, you can't assume what took place under your watch 4, 5 or even 6 years ago will not come back to haunt you, even if it took place at another firm. So what impact will the new regime have on senior managers, Rachel?
Well, with this increased emphasis on personal accountability, we can expect to see more enforcement action taken by the regulators against individuals. So those at the top will definitely be feeling more exposed, and we can expect senior managers to be asking for more money, indemnities in their employment contracts, insurance products, and possibly a contribution towards the cost of taking legal advice on the SOR.
What about the firms themselves? How do they prepare?
Well, for the relevant firms, administrative costs are likely to increase substantially, as ultimately the burden is now on them to certify the fitness and propriety of many thousands of employees, and also to make sure all references are up to date. So firms are going to have to amend or create policies and procedures, amend contracts of employment, their employee handbooks, compensation plans, and various other documents to ensure that they comply with the new regime.
So what's next then, Rachel?
Well, you can see on the slide the key dates that firms and affected employees need to be aware of. And this includes the deadline for issuing certificates and the deadline that the conduct rules will be rolled out to all employees.
So in summary, the SMCR represents a paradigm shift in the way that financial institutions and the individuals employed by them are regulated. It is designed to increase the accountability of the individual and of the firm. And key to all of this is to ensure that SORs are clear and very carefully drafted. There's clearly a lot of detail in the new regime, and it all needs to be monitored closely to avoid issues cropping up. To help you keep track of all that is required, you may find a set of these slides useful. To download them, please go to the link below.
If you require more information, please do contact myself or David. Our details are on the screen. On our website, www.doyleclayton.co.uk, we have a page dedicated to the SMCR. And finally, please do follow Doyle Clayton on LinkedIn. We post regular updates and share interesting comments. Thanks for listening, and we hope you have found this useful.